let us start discussing on the validity of offer. So this means the rules of a valid offer. An offer, in order to be considered as valid, must fulfill these conditions. So first one, intention of creating a legal obligations or legal relationship. So whenever there is we call it as a valid offer, it must intend to create a legal obligation. An offer, if it does not create a legal obligation or legal relationship, we cannot consider it as a valid offer. So we call it as social agreements. So first valid offer rules is that offer must such that it would result in a valid contract when it is accepted. So by creating a legal relationship, a social invitation or a social agreement, even if it is accepted, does not create legal relationship. And the second important rule is that it must be certain, definite, and should not be vague. So what does it mean is the terms of the offer must be certain and unambiguous. If the terms of the offer are vague, no contract can be entered into because it is unclear and it is not exactly the parties intended to do. For example, Anand offers to sell Vikas 100 tons of oil. If Anand is a dealer in coconut oil, this is valid. But however, if Anand is a dealer of multiple types of oil, his offer is not certain because he has just mentioned 100 tons of oil, because it is not clear whether he wants to sell the type of oil which he intends to. So hence, in such case, if Anand is a dealer of coconut oil only, it is clear. But however, if he is a dealer of multiple oils, the offer cannot be considered as valid because offer is not certain. Another example where if Xavier offers to sell his car for Yasin for 1 lakh rupees or 1,50,000 rupees. So here Xavier's offer to sell his car is definite, but the value is not definite as to his offering that 1 lakh or 1,50,000, which is not clear about the prices given. So in such case, we cannot call it as a valid offer considering the uncertainty and vagueness. And the third rule is that it must be communicated to the offeree. So the offer has to be communicated. Otherwise, if it is not communicated, one can accept only the offer when he knows about it. So thus an offer can be accepted only by the person having the knowledge. If he is not having the knowledge, he cannot the other person cannot accept it. So an offer accepted without its knowledge does not confer any legal rights on the acceptor. So this is also very important rule which is to be considered while discussing about the validity of offer. Section 4 talks about this. An offer is complete only when it is communicated to the person to whom it is made. Without communication, there can neither be an offer nor an acceptance. And the next point is it must be made with a view to obtain the assent. So this is part of the definition wherein we have already covered as to the final willingness. The party who is offering must be having a final willingness to do an act with a view to obtain the assent of the other. So meaning jokingly made wherein there is no intention to perform. In such case, it cannot be called as valid offer. So in order to consider an offer as a valid, it must be made with a view to intention of completing it, as if the other party is going to give his assent or consent. So an offer can be made subject to any terms and conditions, but however, it must be made with an intention first that the other party, if he confirms or if he gives consent, it has to be performed. So obtaining the assent of the other, this view is also very important in order to make an offer as valid. And next one is it may be conditional. It may be conditional. An offer may have n number of conditions. The offerer can put conditions, or even it may not have to be conditional. So an offer may be conditional or non-conditional. It is for the offeree to agree the conditions and convey his acceptance. So an offer can be made subject to any terms and conditions by the offerer. The offeree will have to accept all the terms of the offer. Otherwise, the contract will be treated as invalid, because if the conditional acceptance is given, then it will not be considered as concluded contract. So, offer may have n number of conditions, but acceptance should not have conditions. Moving to the next important valid rule is that offer should not contain a term that a non-compliance which would amount to acceptance. So basically, when a person is offering to another person, there must not be any clause or any term which should amount to acceptance if the condition is non-complied. For example, if a person writes a letter to another person to sell his house for 10 lakh rupees, if you do not reply by next week, it will be treated as accepted. So here, a non-compliance means if you do not reply, your silence will be considered as acceptance. So such terms or conditions, if it is put in the conditions of offer, it will be considered as invalid. So an offer cannot impose the burden on the offeree to reply. An acceptance cannot be presumed merely by silence. Hence, the offer must not contain a term, the non-compliance of which would amount to acceptance. So it means that while making the offer cannot say that if offer is not accepted before certain date, it will be presumed that it has been accepted. So in such cases, it will be considered as invalid offer, and contract cannot be concluded. And the offer may be either specific or general. We have already covered this in the different classification of offer elaborately. And another important valid rule is that offer must differ from the invitation to offer. So invitation to offer is different from offer. So what is invitation to offer? When a person proposes certain terms or conditions on which he is willing to negotiate. Very important. So there is no final willingness. In case of offer, we discussed that there is a final willingness. Whereas invitation to offer, there is no final willingness. It is only an initial intention. Basically, the party is saying that I am ready to negotiate when you offer. So when an invitation to offer is given, the party is proposing the certain terms on which he is willing to negotiate and inviting the other party to make an offer. So whereas in the offer we discussed that it is a final willingness which is being expressed in order to obtain the assent of the other, whereas in the case of invitation, it is only an inviting the other party to make an offer. So invitation to offer, his objective is to send out the invitation that is willing to deal with any person on the basis of such invitation. For example, prospectus. When the company is issuing prospectus to the shareholders, prospective shareholders, it means that they are willing to accept the offer if in case the shareholder is interested to buy it. So whenever the company is issuing prospectus, it is an invitation to offer to the prospective shareholders, whereas prospective shareholders, when they apply for the shares, they are offering, and it is up to the company whether to accept it or not. So invitation to offer cannot be considered as equal to the offer. So moving on to the next classification, valid rule: express of offer, or it may be implied offer. So contract to conclude as a valid contract, an offer may be through implied or express. So here implied or express offer, meaning express offer when offer is made with the express words, or in a either it could be in oral or written form, it has been expressed, whereas implied is nothing but by the conduct of the parties. So for example, for express offer is that when A proposes by letter to sell a house to B for 25 lakh rupees, wherein the implied offer, wherein the example could be a particular bus operator operates a bus from Bangalore to Mysore. It is an offer by conduct to take passengers. So the bus is standing at the platform in the bus terminal with a view to taking the passengers. Once the passengers board the bus, there is acceptance. So offer can be express or implied. So this is even an implied offer is also a valid offer. So the next valid rule is that statement of price is not an offer. An offer should be distinguished from an invitation to offer. This is similar to the previous discussion we had made with respect to the invitation to offer. So invitation offer is only a circulation of an offer. It is an attempt to induce offers and precedes a definite offer. So it invitation to offer or a statement of price does not result in contract, and only an offer emerges in the process of negotiation. So why this particular statement of price is not an offer? Because if price statements were become binding offers, anyone could force a sale by saying just I accept this offer. So hence it would be unfair to sellers who might want to negotiate or change their minds. And also the law protects the people from accidentally creating contracts. So examples could be display of goods, or advertising auction sales, or quotation of prices. And another example is statement of price. So whenever the offer person is quoting the price without having any final willingness, if he just merely quotes a price or merely states the price, cannot be regarded as offer.